If you're a parent here in South Carolina who's helped your adult child purchase a home, maybe you're on the deed, this video is specifically for you because there's a good chance you're paying too much in property taxes and you don't even know it. I'm James Anderson with Anderson Law Firm, and today I want to talk to you about our residence trusts and how they can save your family real money. Here's the problem. Mom and dad helped their adult child buy a house. Maybe they co-signed, maybe they're on the deed for financing reasons, or simply because they don't trust their child or their child cannot own real estate. Maybe it was an investment. Maybe their child's off to college and they figured they'd buy a condo there at Clemson or down in Carolina for their student child and their friends to live in, and also be an investment down the road. Whatever the case may be, if the property's in your name and you're not living there, as you probably know, you're being assessed at our full 6% property tax assessment ratio. Compared to the 4% primary residence tax assessment ratio, that's a 50% increase. On a $300,000 home, that difference adds up to real money every single year. So when mom and dad are on the deed and don't live there, the county sees it as non-owner occupied. Your child is living there, but the ownership structure doesn't qualify for the 4% rate. You're leaving money on the table. This is where a residence trust can come in. A residence trust is a specific type of trust designed to hold residential property. Here's the key. When the property is held in a properly structured residence trust and the beneficiary, that being your child, lives there as their primary residence, the property can qualify for that 4% owner-occupied tax assessment ratio. So instead of your child paying property taxes based on the 6% rate, who are we kidding? It's you paying the property taxes, right? You're paying based on the 4% rate, the same rate every other homeowner in the neighborhood is paying. And here's what I really like about this structure. It also gives you, as the parent, a clean way to maintain some control. In other words, you can be the trustees of this trust. You set the terms of the trust. You talk about what happens if your child moves out, if they want to sell, if circumstances change. It'll also keep everything out of probate should any of the players pass away. So there is a built-in estate planning component as well. What I mean is that with the property in trust, when something happens to you or your child, there's no probate on that property. It passes according to the terms of the trust. Clean, simple, and fast. I want to be clear, this is not a one-size-fits-all solution. The details matter, how the deed is structured, who the trustee is, what the trust terms say. This is something that you want to get right, not because the county assessor's office is going to look at the actual ownership structure, just who lives there. If this sounds like your situation, if you got your name on a house your child lives in, come on in, come talk to us. We've got detailed information on residence trusts on our website at sclegacylaw.com, and we would love to walk you through your options. And because I know you're going to ask, we charge a flat $2,500 fee for this service. That includes the drafting of the trust agreement, the deed to move the property into the trust, and then we will help you with the paperwork with the county to get that 4% assessment ratio. Thanks for watching. If this was helpful, share it with a friend who might be in the same boat. I'll see you next time.